What if I told you that the concealed carry permit sitting in your wallet right now, the one you stood in line for, paid for, trained for, might actually be worth less than the paper it's printed on? Not because you did anything wrong, not because the law changed on you, but because the state you live in quietly decided that your constitutional right to carry stops at almost every door you walk through. A grocery store? Off limits. A restaurant? Prohibited. A shopping mall? Forget it. A parking lot? Technically, no. And here's the part that should make every single gun owner stop and pay attention. The Supreme Court of the United States already said states cannot do this to you. And right now in 2026, 9 justices are deciding whether to enforce that or let states keep getting away with it. This is not a future problem. This is happening today. And if you don't understand what is at stake in the next few months, you could be carrying illegally in places you thought were perfectly fine. Or worse, you could be leaving your firearm at home in places where your life depends on having it. Stay right here, because what I'm about to lay out for you changes everything. Before we go any further, if you are serious about your Second Amendment rights and you want to know the moment this ruling drops, hit subscribe right now. I cover every major court decision that affects gun owners the day it comes out. No spin, no politics. Just the law, explained in plain English. Hit subscribe, then let's get into it. Let's go back to where this all started, because you cannot understand where we are in 2026 without knowing what came before. For decades, a handful of states had a system in place called may issue licensing. That phrase sounds harmless, but let me tell you what it actually meant in people's lives. It meant that a government official, sometimes a police chief, sometimes a local judge, sometimes a clerk behind a counter, or had the power to look at your permit application and simply say no. Not because you were a criminal, not because you failed a test, but because in their personal judgment, you had not proven that you specifically needed a firearm for self-defense. Think about what that means in practice. You are a woman living alone in a high-crime neighborhood. You apply for a concealed carry permit. The official reviews your paperwork and decides that your fear, your neighborhood, your circumstances are not compelling enough. Denied. You are a small business owner who carries cash home late at night. Same process, same judgment call, same answer. Denied. This was not a hypothetical system. This was the reality in states like New York, California, New Jersey, Hawaii, Maryland, Massachusetts, and Rhode Island, plus Washington, D.C. Millions of law-abiding Americans who did everything right were being told their safety wasn't worth a permit. And the courts, for years, allowed it to happen. Then came June 23rd, 2022. The Supreme Court handed down its decision in New York State Rifle and Pistol Association versus Bruen, 6 justices against 3. And what those 6 justices said was simple, direct, and historic. The Second Amendment protects your right to carry a firearm in public for self-defense, not just inside your home, not just on your own property, outside, in public, as part of your daily life. And no government official gets to override that right by deciding your personal reason isn't good enough. That was the end of may issue in America. Overnight, the states that had been running that system were legally obligated to change. But here's the part that most people never talk about. The ruling did not just affect New York. It changed the entire legal framework that courts use to evaluate gun laws across the country. Before Bruen, courts would balance the government's interest in public safety against your individual gun rights. After Bruen, that balancing test is gone. Now, the government has to prove that any restriction on your Second Amendment rights has a direct historical parallel going back to America's founding era. If they cannot find that historical tradition, the law fails. That is a seismic shift. And the lower courts have been wrestling with it ever since, which is exactly why we are still fighting this battle in 2026. Quick pause. If you've got a friend or family member who carries, do them a favor and share this video with them right now. Most concealed carry holders have no idea this legal battle is happening or what it means for where they can legally carry. Send it to them. It could genuinely matter. So the Supreme Court ruled in your favor. Case closed, right? Not even close. Within weeks of the Bruen decision, states that lost their may issue systems did not accept the outcome quietly. They regrouped and launched a counterattack. The strategy was clever. If we cannot stop people from getting permits, we will make those permits useless. New York moved first. Just weeks after losing in the Supreme Court, the state legislature passed the Concealed Carry Improvement Act. Under this new law, your permit was suddenly invalid in an enormous list of places. Public transit, restaurants and bars that serve alcohol, Times Square, parks, entertainment venues, libraries, playgrounds, and essentially any location the state deemed sensitive. The list was so long that gun owners realized their permit basically only worked in very specific, limited circumstances. New Jersey did the same thing. California followed. Maryland added its own version. Each state was playing the same game. redefine sensitive places so broadly that even though you have a legal permit, you cannot actually carry in the real world where you live and work and go about your daily life. This is not a minor legal disagreement. This is a direct attempt to nullify a Supreme Court ruling without technically violating it, and millions of permit holders got caught in the middle. Which brings us to right now, to the case that has gun owners, state legislators, and constitutional lawyers all watching the Supreme Court very carefully. It's called Woolford versus Lopez. And it started in Hawaii. After Bruen came down, Hawaii passed a law with a rule so strict that legal reporters started calling it the vampire rule. Here's how it works. If you have a concealed carry permit in Hawaii, you cannot bring your firearm onto any private property that is open to the public, places like restaurants, shopping centers, banks, parking structures, bars, unless the property owner explicitly gives you permission, not a general policy posted on a sign, not an assumed welcome. The owner has to specifically invite you in with your firearm, like the old folklore rule about vampires not being able to enter a home unless the owner invites them across the threshold. Gun owners in Maui challenged the law. The case moved through the federal courts. The Ninth Circuit, one of the most liberal appeals courts in the country, sided with Hawaii. And then on October 3rd, 2025, the Supreme Court announced it would hear the case. Oral arguments were held on January 20th, 2026, 2 full hours of argument before all 9 justices. And what came out of that courtroom was remarkable. Legal reporters covering the session said the conservative majority, all 6 Republican-appointed justices, showed clear skepticism toward Hawaii's law. Chief Justice Roberts questioned whether the Second Amendment was being treated as a lesser right compared to other constitutional protections. Justice Alito pressed Hawaii's attorney on whether the state was effectively making the Second Amendment a second-class right. Justice Gorsuch raised pointed questions about whether the government could selectively redefine property rights to specifically undercut constitutional freedoms. Justice Kavanaugh laid out a straightforward position if the Second Amendment covers the activity. In question, and there is no historical tradition supporting the restriction, the analysis should stop there. Even the executive branch weighed in, with the Trump administration's lawyers arguing against Hawaii's position and warning the justices that a ruling in Hawaii's favor could open the door to states banning tenants from owning firearms without landlord approval. The signal from the court was unmistakable. Here is why you need to be subscribed right now. The Woolford ruling is expected by late June 2026. When it drops, I will have a full breakdown live within 24 hours, explaining exactly what it means for your state, your permit, and your rights. That video is going to be essential. Do not miss it. Subscribe and hit the bell so you're notified the moment it goes up. Now, let me be direct about something because I want you to understand the real stakes here. This case is not about Hawaii. Hawaii was just the state where the legal challenge happened to originate. The actual impact of the Woolford decision is going to be felt in every state that passed similar laws after Bruen. And that list includes some of the most populous states in the country. New York's Concealed Carry Improvement Act created one of the most expansive lists of prohibited carry locations in American history. New Jersey's response to Bruen left permit holders with almost nowhere to legally carry in urban areas. California's sensitive places list covers an enormous percentage of the locations where people actually spend their daily lives. Maryland's law was so aggressive that a federal appeals court, the Fourth Circuit, already issued a ruling in late January 2026 saying the state's ban on concealed carry on private property open to the public is unconstitutional. 3 judges on that panel, including ones who disagreed on other aspects of the case, all agreed on that specific point. That kind of unanimity does not happen by accident. The courts are reading the direction the Supreme Court is moving and starting to align their decisions accordingly. Here is what a favorable Woolford ruling could look like in practical terms. If you live in a state that currently bans concealed carry in privately owned places open to the public, restaurants, malls, movie theaters, parking garages, a Supreme Court ruling against Hawaii's law gives attorneys across the country immediate grounds to challenge those same state bans. Cases that are already in the pipeline could see accelerated rulings. Laws that have been holding could fall quickly. The geography of where your permit works could expand significantly. This is not speculation. This is exactly how constitutional law works. The Supreme Court sets the standard. Lower courts apply it. State laws that cannot survive the new standard get struck down. The process is already in motion. So what does all of this mean for you as a gun owner right now before the ruling comes down? 3 things. First, know your state's current prohibited locations list cold. Whatever state you carry in, you need to know exactly which locations are designated as off limits under current law. Those are the places most likely to change when Woolford is decided. Go to your state's official government website or consult a licensed firearms attorney in your state to get a current, accurate list. Do not rely on what you read somewhere online 6 months ago. These laws are changing fast. Second, If you live in a state that has a complicated post-Bruen landscape, meaning your state passed a big list of sensitive places after the 2022 ruling, start paying attention to the legal challenges happening in your state right now. Many of these laws are already being contested in court. A ruling in Wolford's favor will turbocharge those challenges. Third, and most importantly, talk to a licensed firearms attorney in your state. What I am giving you here is the big picture, the legal overview, the context you need to be an informed gun owner, but your specific circumstances, your specific state, your specific situation, that requires someone who is licensed to practice law where you live and who can give you actual legal advice, not a YouTube video. A licensed attorney. Nothing in this video is legal advice. It is educational information based on publicly available court records and legal reporting. Let me bring this all home. The Bruen ruling in 2022 was the most important Second Amendment decision the Supreme Court had handed down in over a decade. It ended a system that had been blocking millions of law-abiding Americans from exercising their constitutional right to carry. But the story did not end there. States fought back. They built walls out of sensitive place lists and private property restrictions, trying to shrink the practical value of your permit down to almost nothing. And now the Supreme Court is being asked to rule on whether those walls are constitutional. The conservative majority that ruled 6-3 in your favor in 2022 is still on that bench. The signals from January's oral arguments were clear. The tide is moving. Your Second Amendment rights are not done expanding. They are in motion right now, in real time, in 2026. The Wolford ruling is coming. It is going to redraw the map of where you can legally carry in America. And when it lands, you need to understand it immediately, because the rules are going to change fast. Subscribe to this channel right now so you are here the moment that decision drops. Share this video with every gun owner you know, because this information matters. And stay informed, because knowing your rights is the first step to protecting them. Stay safe out there. Everything covered in this video is for educational and informational purposes only, based on publicly available court decisions, legal filings, and published reporting. Nothing in this video constitutes legal advice for your specific situation. Gun laws vary significantly by state and are subject to rapid change. Before making any decisions about where or how you carry a firearm, please consult a licensed firearms attorney in your state. Only a licensed attorney can provide advice that applies to your specific legal circumstances.